We're one day away from the PAC-12 hearing.
Conference realignment and expansion is always in the news, so we're back on the big mountain to break it down for you.
Hey, it's good to have you here. I am JY. This is my good friend Steve. We are one day away from the hearing between Washington State, Oregon State, and the PAC-12 and the commissioner.
Yep.
I thought it'd be a great idea at this point for us to briefly go over kind of the last 2 months ish. And I'm going to go over this in a timeline in terms of dates and what happened on certain dates. We have been following this for the last 2 months. I'm going to put links up above here for everything that I talk about. If there's an episode that we've done here in the past, you can hit that up in the upper right, or you can just go to our channel and see all the good stuff we have there. Anyway, let's go back to September 8th. So September 8th is when Washington State and Oregon State took action requesting a restraining order, and this was to stop a board meeting of the PAC-12 and all 12 board members. And I'm not going to get into whether or not there truly are 12 board members. That's what this is all about, quite frankly. So, but anyway, they took action to have a restraining order for that board meeting to not have it happen so that we can have this hearing that is now literally in one day to answer that question of board members. September 11th, only a few days later, Judge Levy grants the restraining order. There was a hearing before him. Both Washington State and Oregon State presented their facts. The PAC-12 attorney presented their facts. We did a really deep dive on that. Again, you can go back and hear that if you want to know more about the restraining order, but he did grant the order and really just gave very limited ability for the PAC-12 board to do some things to keep business moving in good order, but not to have a full-blown board meeting or really do anything else until this hearing is had. September 28th, the hearing date was set for November 14th. We finally got here. It seems like it's been a little while, but we're finally here. October 9th, University of Washington made a motion to intervene and dismiss. Now, I will say it was just University of Washington because this case is in Washington. So this is mainly being led by Washington State and the University of Washington, but really all PAC-12, as we've seen and as we'll get into, all PAC-12 members or former members are wanting to be party to this. There's just only so many things they can do since it's in the state of Washington. Jurisdiction issues. Whitman County, to be very specific. Then on October 25th, Washington State motions for a preliminary injunction giving both Oregon State and Washington State full control of the PAC-12. Again, we broke that down. I'm going to get into that here in a little bit. So the last episode we did here just a few days ago, we talked a little bit more about some of the behind the scenes, if you will, of Oregon State and Washington State. And I want to get into that here a little bit more after we get through these kind of timeline-y types of deals. So that was October 25th. On November 2nd, the University of Washington obviously makes a motion opposing the injunction. So it's point, counterpoint, point, counterpoint. That's how this has always gone. Obviously, the University of Washington would oppose that. And, that's kind of where we're sitting right now. So there's been a lot of back and forth. There has been some items that have come out in discovery in terms of documents that have come out. Again, we've gone through some detail on that. Check back at our episodes if you haven't seen them and you're interested in that kind of thing. The one piece I did want to talk about here briefly, and this is just going to be a real quick, brief episode, but the last time we talked was about how some information came out regarding Washington State and Oregon State also looking to become members of another conference. And again, we talked about how that wasn't surprising. They all were probably doing that, backstabbing each other, so to speak, or at least, and as you've mentioned, having a fiduciary duty to their schools to ensure that they're able to move forward in the best way possible. All of that makes sense. But one thing that I'll give a shout out to one of our special guests. So a special guest we had a while back, Jim, he actually brought this to my attention, and I thought it was really interesting. I am not an attorney. I don't claim to be an attorney. Neither of us do. But I did do a little research on this to see if it is something that possibly could come up. I think it may be. And it's called the Unclean Hands Doctrine. And this really mainly applies to equitable types of claims, such as injunctive relief, exactly what we're talking about here. And I guess the question is, does some of the facts that we now know about Washington State and Oregon State doing the same sorts of things, having, in this case, dirty hands, about backstabbing each other, will this come into play with this case, especially this injunctive relief case? So I'm going to read a real brief definition of it just so people go, what does that mean, dirty hands? So basically, it's a defense to a complaint in which a party who is asking for a judgment in which they also have done anything unethical or in bad faith. I think unethical here is pretty heavy-handed in terms of that language, but bad faith, I think they are all doing things in some way in terms of bad faith to each other. In relation to the subject of the lawsuit, would this be something that applies to the other 10 schools? Because those schools, I don't think it applies to the PAC-12 necessarily, or the commissioner, but I definitely think, we go back, we talk about Washington made a motion to intervene and become a party to this case. I think they could have a claim where they could say, hey, this unclean hands doctrine could apply to you because you did the same thing to us. So don't hold yourselves all high and mighty when you were doing exactly the same things as we were doing. Now, we talked about that in the last episode. I think you made a really good point that you just said it kind of, the victim card is maybe decreased slightly with that. But I don't know how you feel about this. I know we haven't really talked about this before this episode. What are your thoughts on that, Steve?
I mean, I think that it makes sense. For whatever reason, I always go back to it kind of reminds me of a divorce. A divorce is breaking like a civil union, a family, as far as in court, and you're basically separating assets and all that kind of stuff. And to me, this just that entire concept to me, kind of relates to when one party in a divorce is saying, hey, I want a divorce because you did something wrong, you cheated or whatever, and then if the other party has some kind of evidence that they did something wrong, they can offer that to kind of take away that advantage. So a lot of Washington State and Oregon State's strategy so far has been basically to show the other teams are leaving, they're kind of screwing us over and leaving us holding the bag. And so we need this relief because we have to pick up the pieces, we're still here and all that. Which I do think there's a lot of validity to what they're saying. But I do think this would be a smart strategy for the treasonous 10 to use to show, we're not all that bad. Everybody was looking. Everybody was trying to get out. It just happens to be the game of musical chairs. You guys were the last two standing without a chair. So a lot of the things that you're saying that we did, you were also doing. So it makes a lot of sense to the point of I do think that they're going to have trouble proving that and getting some kind of benefit from it, but it's a good strategy because I think their best strategy, the treasonous 10, they're leaving, is to get this to a settlement. Get a check on the way out the door. They know where they're going. It really doesn't matter to them for the most part what happens with the Pac-12. They don't want to go to their new home completely broke. Okay, they want a check out the door. They want a settlement. So I do think this would be a good strategy to try and get it to that point. Basically, because if you want a settlement, you want a mediation settlement, you want to show that all parties are equal, and this would be a great way to do that.
It was interesting to me. I had not heard of that before. I looked into it and I went, wow, this really seems to apply. Again, as I said, it applies to equitable types of claims. So that's exactly what we're talking about here. Injunctive relief for equitable types of claims. I'm anxious to see what happens here, assuming the hearing takes place. I mean, hell, in the next 24 hours, a settlement could come up. That could be what happens right before any sort of case gets going. I would guess at this time frame, it's probably unlikely. I would think not a settlement. I think a settlement still is probably in the best interest and most likely, but I think a hearing will likely at least ensue and begin, and then we'll have to see how things play out from there.
Yeah, and if I could add another point, something that you and I have talked about on other episodes is also related to the dirty hands is a conflict of interest.
Right. Yes.
There are so many conflicts of interest, and basically the different sides accusing each other of conflicts of interest, and it's still, to me, it's not lost on me that the president of, I think it's the president of Oregon State, Washington State, Schultz was the president of the board.
I think
he still is the president of the board when all this was happening. So I think as we move forward and through discovery, he had to wear two hats. There were different times to wear two different hats. What was he saying and doing as the president of the board versus what was he saying and doing as the president of Oregon State University? Was there any conflict in there? Is there anything that could, in communications back and forth between the president of the board and the conference, the commissioner, is there anything that could show that conflict of interest or show the dirty hands doctrine? And so I think there's so many pitfalls.
Yes.
There's so many things with that. And again, it just leads me back to, I think the best case for all parties is to come to a settlement.
Yeah, I think that leads down this same exact path. And we've seen, I don't know how much, I really don't, but we've seen a taste of what was done by both Oregon State and Washington State. And I think you make a good point there in terms of a conflict of interest, dirty hands, kind of all, we're talking about a little bit of the same thing here. But yeah, it's going to be really interesting to see how that plays out. I mean, this could get really dirty. Yeah. It already has gotten somewhat dirty, but it could get really dirty, and there's really no winners in that. And I think it really depends on how far people want to push this. Yeah. If they both are understanding to the point where, hey, we're going to come to an agreement that this year we'll get through it, we'll share equally, and then moving forward, we'll have some sort of a departing agreement, because we've talked about everybody wants to talk about assets and liabilities, but again, or assets and revenues, but there's these liabilities that I would think, if I was Washington State and Oregon State, if there's these other 10 schools that have to be, or that we would want to be party to these liabilities that have been around for years now, you'd want to try, I don't know how you do this legally, but you want to try to keep them on the hook through a settlement or through some sort of sunsetting, or, again, I don't know how you would do that. But I'd be way more honestly interested in making sure they're on the hook for potential liabilities that were done years ago that really were because of them or because of the 12 of them. And so that Oregon State and Washington State aren't holding the bag for the Pac-12, because the Pac-12 is 2 schools right now.
Right.
So they're holding the whole bag for that. So a lot of questions there that we don't have the answers to, but interesting stuff.
Can I bring up one more point?
I love it.
Okay, something that I want to talk about. Yep. So when the first, you mentioned back on, I think it was September 9th, when the first hearing, there was a lot of people that took shots at our beloved judge up there. And what's the county's name again? Whitman County. And
Judge Levy.
Yeah, Judge Levy.
Yeah.
And he had a folksy way about him and talked about there's only 2,000 residents of the town or whatever, and we don't see these kind of things too often. Right. But when you look back, I went kind of back and looked at our episode we did about that, and looked at some of my notes. He was spot on from the beginning. He said right away, we need to get these other parties joined to this. Basically everything he said was, let's get everybody in a room, because there's a lot of parties that are going to have a say in this. He did give that temporary restraining order, and I'm sure there were some people that weren't very happy about that. But the reasons he gave and what he did were spot on from the very beginning of, there are so many parties in this who have an interest. Let's get everybody in a room. We're going to move forward with this hearing tomorrow, and I'm excited about it. Yeah. But I think he had it nailed from the beginning. That let's get everybody in a room, let's talk about it, let's figure out a way, because there's going to be hurt feelings, there's going to be problems, like you said, it's going to get dirty and messy. Yep. So the best way, let's get everybody together, let's figure out a solution that makes everybody happy, right? And maybe everyone's going to be pissed, but basically addresses everyone's concerns. So we're back to square one. We kind of made fun of the judge at the beginning for being a local yokel a little bit, but he was spot on. We're going to be back in his courtroom. I'm really excited about it. I'm interested about it. Yep. You and I are going to watch it, so they don't have to.
That's right. And as I said before, in a settlement, if there is one, If there's no winners and everybody's pissed off, that means it's a good settlement.
Right.
So anyway, hey, we thank you for tuning in. Just wanted to do a real quick update. We're finally here at the hearing. And if Steve and I will be on this and watching this again, we're not a breaking news channel, so it may be a couple days until you hear from us, but you're definitely going to get the facts from what we hear, as well as our opinions on it and where we see this heading. So with that, hey, we'll see you next time on the Big Mountain.